And welcome. I forget about that little voice every time. Good morning and welcome to the Committee on Professional Responsibility and Conduct. This meeting is being recorded, and I will ask Angela to please take the roll.
Okay, taking roll. Benola.
Here.
Bradley. Brown. Chivers.
Here. Sorry.
Desmond. Krieger.
Here.
Mark.
Here.
Mercado.
Here.
Muse.
Here.
O'Reilly.
Here.
Poindexter. Robbie.
Here.
And Starr. Thank you.
And Bradley is here.
Oh, Bradley. Thank you, Elizabeth.
And Angela, I think Raquel is here as well. I just promoted, she was in the attendee pool, so I just promoted her, so she may appear in a moment.
Okay. Is that in process, Erica? Should we proceed?
It is in process. We're having a little bit of a technical issue. I'm promoting, but it's not working. So we'll give it a shot in just a minute.
Okay. Should we go ahead with the public comment? Oh, great. There's Raquel. So first item on the agenda is the call for public comment. And so State Bar staff will now attempt to call members of the public in the order that they appear in the attendee pool.
Okay, if you are participating by Zoom, you can use your raise hand function right now at the bottom center of your screen to address the committee, and we'll call on you in the order that we receive the hands. For those participating by phone, please press *9, star key, number 9 key to raise your hand, and each speaker will have 3 minutes. You'll be verbally alerted at 30 seconds, and when your time is up, please wrap up your comment. Is there anybody who'd like to give a public comment? Please raise your hand. Okay, first I have Lori Taylor. One moment. Lori, when you're ready, go ahead and start your public comment.
Can you hear me?
Yes.
Thank you. My name is Lori Taylor, and I'd like to comment on the agenda item under D, new topics, 2, consideration of lawyer assistance with abortion access opinion. I'm a bar member and an advisor to the overarching reproductive law project, which has written the bar in the past with questions regarding lawyers who help their clients determine how they can get essential health care. I want to reaffirm my written comment earlier and thank the committee again for responding to our concerns in the past, including during the drafting of Rule 8.3 on mandatory reporting. We've been very gratified by COPRAC's consideration and its response. California attorneys who work to advise and represent clients in other states seeking reproductive health care are in a bind. In California, every attorney takes an oath to support the California state constitution. That constitution designates abortion and contraceptive as fundamental rights grounded in equal protection and the right to privacy. But how can we confidently advise clients in states with laws that restrict or ban this essential health care, which is guaranteed in California? If we face discipline, prosecution, or civil action in restrictive states, even if the care that our clients seek is legal where it is provided, will the California State Bar impose reciprocal discipline under current rules and statutes? The chilling effect on lawyers who want to represent their clients effectively is very real. The California State Bar can lead other bars in states where reproductive health care is legal and whose members ask the same question. How can we as lawyers ethically advise and represent every client without fear of legal or professional repercussions? We need guidance from COPRAC to advise us on compliance with both the rules of professional conduct and the State Bar Act, and where changes to those rules or statutes may be unnecessary. There's a lot of uncertainty, and this requires clarity. I look forward to the committee's work, and I thank you.
Thank you, Lori. All right, next we have Stephen. Stephen, you may start your public comment when you're ready. Your mic is muted as well. Stephen?
Stephen, if you're appearing by phone, you'll need to hit *9
Oh,
to
there we go.
unmute. There you go.
Okay, now can you hear me?
Yes.
Okay. So I'm a member of the public. I kind of just had like a comment from like a recent experience with the California State Bar, and from my understanding, the State Bar is described to have a critical mission in protecting the public and ensure the ethical and competent practice of law, with one of its primary functions being the discipline of attorneys. For the record, my complaint was recently closed, to which I was given the option to wait 10 months for the CRU unit to decide whether they are going to reopen my complaint or not. This is disheartening to say the least. My situation is actually conveniently one of your guys' topics that you guys are going to discuss today, being the American Bar Association Rule 1.16. Our old attorney, me and my girlfriend, I say our, he had abandoned our case, and after having effectuated a settlement offer without our approval, we refused to sign the settlement release and he withdrew. So there's like, I'm just wondering at what point, because I've been told that that my situation wasn't big enough or wasn't grand enough to prosecute. And if it's like if my situation is one of your guys' topics today, it's just like I don't know why it's even being discussed if it's not going to be like enforced and stuff like that.
Thank you, Stephen. Are there any other public comments? If so, please use the raise hand function at this time. I don't see any other public comments.
Well, great. I'd like to thank the members of the public who commented. I'd like to move to approval of the minutes of the last meeting from the January 12 open session minutes.
So moved.
Thank you, Joel. Is there a second?
Second.
Great, thank you.
I will take the vote to approve the minutes. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Desmond, Mark,
Yes.
Mercado,
Yes.
Munoz,
Yes.
O'Reilly,
Abstain.
Poindexter, Ravi,
I will abstain.
Starr, and Krieger.
Yes,
So 7 yeses to abstain, the motion carries.
great. So I'm going to move on to the, oh, we're getting some sort of feedback, or at least I am. I'd like to move on to the staff report. I don't have a chair report for this meeting.
Thank you, Brandon. I'll be pretty brief. So first, a quick reminder, there are currently 2 opinions out for public comment, with that public comment period ending on April 30th. Those are the arbitration advisory opinion 2022-0XA, which is the standard of review and fee disputes when there's a written fee agreement. That was the addition of the PEC case. And then as well is 21-0003, which is the ethics of in-house counsel. Just an update. So far, we've received very little, if any, public comment on both of those items. So I'm guessing 2 full months to go. So we should have some public comments coming in hopefully soon. In regards to the other 2 opinions that were voted out, that's the succession planning opinion and then updates to the published colleague impairment opinion to reflect changes, including the addition of Rule 8.3 and then to clarify some information about the lawyer assistance program. Those should be issued for public comment starting likely next week. We try and stagger when items are issued for public comment to give bar associations more opportunity to have time to weigh in on them. And then we're also just finalizing the updates to the research related to the lawyer assistance program, the reports and things that indicate issues with impairment and substance use and mental health issues. Switching gears, so in the next couple weeks, you will likely receive your Form 700, which, as you'll recall, is that document that you need to complete that relates to potential conflicts of interest. We had a representative, Brady Dewar from OGC, come and present on that requirement. I believe it was at the January meeting. So you should receive that in the next couple of weeks, and we'll be contacting you if for some reason you have any issues with that or you're not receiving it. If you have questions about the substantive completion of the form, please reach out to me and I'll coordinate getting you in touch with our general counsel's office to help you answer any questions. And then last but definitely not least, I want to introduce very quickly Steve Moad, who is the special counsel to the Division of Regulation. And just the reason he is here is that effective on February 1st, the Office of Professional Competence, which is the office that Angela and I work in, was part of a reorganization at the State Bar. So you will not see Bridget Grammy at our meetings anymore. She is still at the State Bar, just responsible for other large offices. And we are now within the Division of Regulation. And regulation, as some of you may know, does a host of things, including the Client Trust Account Protection Program, the rollout of that, and now the annual process for it, including eventually compliance audits and other things. So it really makes sense. We in OPC have spent a lot of time with attorneys looking at CTAP issues on the hotline and providing education related to that. And the Division of Regulation is also doing a lot of that work. So it kind of just makes sense to bring us together, as well as the Division of Regulation does a lot of other attorney compliance related work, just like OPC does. So it's kind of a merging of two offices that are already doing a lot of the same work to make sure that we're doing it together and in a way that makes the most sense for attorneys and for the State Bar. So I'll let Steve introduce himself, and I'm sure he can answer any questions you guys might have.
Yep. As Erica said, my name is Steve Moad. I'm happy to be here and happy to be working more closely with Erica than I have in the past. I've had opportunities to work with her and with OPC before, and it's been very informative and it's been great. So look forward to more of that and to learning more about all of you and the committee. So happy to answer any questions if you have any.
Welcome. Thanks for joining us.
Absolutely. Thank you.
And that concludes my staff report.
Great. I think the next thing we should talk about, and I don't know if it's going to be quick or extensive, would be the status of the symposium preparation and planning. So I will turn that over to Erica as well, because I think most of the information is funneling through staff.
Sure. Yeah. So most of the work is actually being handled by Angela and me behind the scenes. So thank you to both of them for doing all of that work. But we are ahead of schedule, which is fantastic. So we do have Vikita's program. She has all of her speakers lined up. And I believe Joel has all of his speakers lined up as well. And we're working on getting a few for the AI program. But we really have it in pretty good shape. So the announcement, kind of the save the date, should be going out next week for the symposium, which is on April 19th, in case it's not on your calendars. And then with that, shortly thereafter, the save the date will include the topics. So as you'll recall, it's the recent developments topic. It is, Joel, you have a catchy title, but I can't recall it off the top of my head, but it's for solo and small firm attorneys. Flying solo, I think is what it was. And then there's the AI presentation, and then there's also going to be an implicit bias presentation. So we will have that save the date posted, and then the course descriptions will obviously go out. And I believe we are just waiting on finalizing speakers for the AI program, but otherwise we are in excellent shape for that presentation on the 19th.
And could you remind us of the deadline for the written materials?
The February 26th to March 25th is when those should be produced. So if you can give them to me by March 25th, that would be good, just because on some written materials, we'll probably need to seek reprint permission.
Okay.
But I'll send out a reminder a couple weeks in advance, just so you have that.
Thank you.
Great. Does anyone have anything to add about symposium planning? Oh, yes, Raquel.
Hello. Two things. One is related to me, and the other one is just related to, well, I think at the last meeting, we did not say what the recent development topics were going to be. So has whoever's working on that finalized that? So that's a question. The other thing that's related to me was that I had originally volunteered actually for AI, and at the time we said, oh, we're not going to have an AI. And so then I got matched up with Cassidy for recent development, which was yet to be defined. And then Brandon, subsequently I heard from you to say, hey, we think you're not appropriate for that. And so I don't know where the sort of the miscommunication was, but I actually wanted to do AI. I wasn't like
So,
I wanted to do recent
Raquel,
developments. But let me just say, nonetheless, I just want to say that we can go as planned with whoever's going to be the attorney working with Cassidy on recent developments, and I think you're going to do AI, and that's fine. So I just wanted to clarify that I actually that I sort of wasn't the one that said I should be on it. Although I don't think it's so technical that a public member could not participate on it. So I think, we participate in all the meetings, so I don't think it's above us to be able to share information. So I would just say that I think it's a bit limiting to say that a public member could not, like, oh, we couldn't understand enough to share information, which is basically one way. So it's not like we're going to be having to fill some level of technical legal question. So, but that's that's a different point. Yeah, I think that's a broader point.
So both of your points,
I'm over.
Both of your points are really good, and I think almost the entirety of the confusion and failure was on my end, not focusing on what the recent developments would be doing. And I welcome you to be part of the AI panel. And if that was your interest, I apologize. You're welcome to work on that with me. And you were part of the AI working group. It seems like a great fit. The idea about a non-attorney member doing the recent developments, it was foolish of me to not think about this earlier, but it seemed like not a good fit when the majority of what we're going to be doing is talking about developments in case law, developments in other ethics cases that impact attorney ethics. It seemed that should be done by attorneys, and historically has always been done by leadership. And I was a little casual with that at the last meeting out of pure laziness. So I actually think all the failures rest right here. Explanation right here. And Raquel, I'd be delighted to talk to you if you're still interested in the AI panel.
Okay. And no blame or, I just want to share.
Sure. And that's my, I think that's the explanation. I wasn't paying enough attention to what I was saying, which gets people into trouble. So any other thoughts on the panel or the symposium? All right. Well, great.
The first question wasn't answered. What are the recent developments that are being considered?
Yes, we have a list. I need to find the email. If anyone, Cassidy or anyone else has that email handy, Sarah, we're doing a BASF opinion, a couple cases, civility. What else? My memory's poor.
Reporting professional misconduct, some recent case developments that you mentioned. It was on attorney withdrawal and
extortion versus threat to sue.
Oh yeah, settlement. Yeah.
Where you
and then the recent in-house counsel ethics opinion that just went out for public comment. So there are six topics that are on the recent developments panel.
And the first thing you said is that 8.3, Sarah?
Yes.
Reporting. Okay. And it's how many minutes? How many minutes?
I think they're each an hour and 15, if I recall. I see Erica shaking her head, so I think that's right.
They're an hour 15. Usually it's an hour of substantive and 15-ish minutes of question and answer. Yeah.
Okay. 6 sounds like a lot, but you'll see over.
We will.
Yeah, we've been able to do it in the past. That's kind of how I think the last 3 panels I'm aware of did 6 topics, and it seemed to work out okay.
Anyone else have any thoughts on the symposium? Well, all right, hearing nothing, I think we will move on to the first opinion that we're going to discuss. It's a draft that's been around for a while. It's the lawyer as expert witness draft, and we've had a working group digging in. We've got a lot of questions, but we've got a revision that was circulated for about 2/3 of the draft, and Sarah's going to walk us through that a bit.
Sure, and just give me 1 minute. Easier if I pull it up on my end. So I think I'd like to start actually not with the questions, which I want to open up for discussion, but I'll first go over what's a little bit easier to discuss right now is just some of the red line edits that we've made. And just as a quick kind of, because some people might have forgotten. So this is an opinion that went out for public comment a while back, and it's been delayed for various reasons at different meetings. So we're now incorporating some of the public comments we received. So I'm going to go over how we incorporated the red lines, and then I'm going to come back to what the working group would like to discuss, kind of two kind of key substantive issues. But I'll first just go over some of the red lines that were substantive. And the first is shown in the digest. And this was based, and I'm going to forget which bar association provided this public comment. Might have been, I think it was 2 actually, the Orange County Bar Association, and Brandon, what was the other bar association? Was it California Lawyers Association?
I think
maybe
it might have been. I think it might have been.
Yeah. And so I think they expressed that, we say in the digest and also in the conclusion and other parts of the opinion that the lawyer might be under common law confidentiality type obligations stemming from the lawyer's role as an expert, but we never really explain that further on in the opinion what we mean by common law, and they're not aware of what that could entail. And we thought about it and decided we should really just focus on contractual or other confidentiality obligations, which we explain below and expand to include, for instance, a protective order that the expert might be subject to. So that's this change to the digest, and we've made changes in other sections of the opinion as well to address that. And so then if you could scroll down, and I'm doing that on my end. The next change, which appears on page 3 of the opinion. Let me just see. Okay. That's not, oh yeah, if you scroll up a little, I think. Yeah, right there. So the language that's been stricken here is talking about when the rules, the conflict rules apply. And initially it had said when the conduct in question either is or reasonably could be viewed by a layperson as the practice of law. And 2 of the public comments by some of the bar associations had felt that wasn't really the correct standard. And whether the view of a layperson. And so we reconsidered that and decided that is actually correct. And we should just focus on whether the lawyer is engaged in the practice of law and in the context of an attorney-client relationship. And then we added support for that as well. As you can see, the new footnote looks like it's showing up as footnote 5, which it's a older COPRAC opinion, which clarifies that when the lawyer is performing tasks that are traditionally understood to constitute legal services, such as providing legal advice, reviewing legal documents, the lawyer must comply with the California Rules of Professional Conduct. So that was just to show that in that context, the rules would apply and provide some support, because some of the public comments said we should provide support for the statement we're making there. And then the next change, which is on the next page about disclaimers, this was just kind of some of the public comments felt that we should provide this type of warning, even though the fact situation here is it's not just a disclaimer. The way we've set up the hypothetical, it's acting in accordance with those disclaimers, but just to warn attorneys that disclaimers alone wouldn't necessarily avoid the formation of an attorney-client relationship, which could be expressed or implied based on the party's reasonable expectations under the circumstances. And then again, we added some support for that proposition to two cases. And then we went into the facts in our hypothetical. So that's the next change. And then if you could scroll, let's see, I guess the next change is on page 6. Yeah, that's okay. So in this one, I think we were just providing more of a clarification that, and this was again based on some of the public comments, that there's no indication on this scenario that the lawyer's testimony would injure the former client in the commercial leasing matter in which the lawyer's law firm previously represented the client. And then we added a footnote clarifying, because I think some of the public comments found it confusing because they felt that clearly the expert testimony may negatively impact the former client in the trade secret matter. And there should be a correction, Angela, if you could correct this to the footnote. But the expert testimony may negatively impact the former client in the trade secret matter, but the law firm does not represent the former client in the trade secret matter. Somehow that, so if you could add does not in footnote 9. Okay. Okay, and the next change is we decided after considering some of the public comments, although we had some part of the opinion in the body, we discussed kind of wanted to disclose to the public kind of the risk of disqualification. And some question whether that's really more of an issue of law that we shouldn't address through an ethics opinion. And we had debated this in our COPRAC meetings going back as well, the same issue. And so we thought it's probably more appropriate to address it in a footnote. That's what one of the public commenters recommended, and we thought that was a great idea. So we moved the discussion and shortened it on the risk of disqualification to footnote 10, essentially. So you'll see that's why all this is stricken on page 6 and it's shortened and incorporated into the footnote. And then moving on to scenario 2, which is the testifying expert first, and then the lawyer representation. A lot of these changes are to just clarify that in this situation, the testifying expert was engaged in, and as I read this, we shouldn't have said his individual capacity. We should change that to in their individual capacity, or in the lawyer's individual capacity, or in the, well, it's not really as a lawyer, but in the expert's individual capacity. And the expert's law firm is not a party to the engagement agreement. We wanted to clarify that, and I'm going to come back to that issue later because we have a more of a substantive question relating to that situation. And again, if you scroll down kind of to the bottom of page 7, that was a minor change, so I don't think we need to go over that. But yeah, the bottom of page 7, yeah, going on to page 8. Sorry, this change was just based again on some of the public comments, which thought we should also warn of the, not only might there be contractual obligations based on the expert's engagement agreement, but the expert could also be subject to a protective order in the litigation that could impose duties on the expert not to use or disclose confidential information. So that would also be a relevant factor that should be considered. So we added that here and throughout. And then we also talked about the potential of material limitation conflict that could arise from the expert's confidentiality obligations under either the contract or protective order, to the extent that might impair the ability to make the needed disclosures under the rule and obtain the defendant's informed consent. Then that would prohibit the representation. But under our facts, we did not believe there would be a material limitation conflict. The changes again, kind of towards the bottom of page 8, the second to last paragraph, are really just to clarify again that in our factual situation, there wouldn't be necessarily a conflict, because here it was the expert was the only one working on the matter. The law firm wasn't a party to the engagement, and no other lawyers at expert's law firm worked on the expert engagement in this factual scenario. And then I'm not going to go over scenario 3. We have we don't have any changes yet because we want to talk about that some more. So I think at this stage, it makes sense to go over kind of the two key substantive questions we had. But before I do that, I know I went through these fairly quickly. I wanted to just pause and see if anyone had questions about the revisions we've made so far based on the public comments. Okay, so not hearing anyone, I'm going to go on to the working group's two key questions. So one issue, and this came through at least two or maybe three of the public comments, pointed out that they feel that we should consider expanding the ethics opinion because, you know, our facts are fairly limited in which the expert is engaged solely as a testifying expert, not as a consultant. But in practice, the way it typically works in many situations is that an expert might first be engaged as a consulting expert before being disclosed and engaged as a testifying expert. So the expert really isn't solely offering expert testimony as we've assumed for purposes of this ethics opinion. So some of the public comments thought we should revise the opinion to address this situation because it is common. And then the other question, the other nuance is kind of considering how the engagement agreement is part of our hypothetical. In ours, we're saying the expert is engaged and the law firm is not a party to that engagement. But we're also questioning, is that realistic, or should we also address a hypothetical situation where the law firm is being engaged and not just the expert? The law firm is a party to the engagement. So those are two questions we had. I think the first one that was through the public comment process about the consultant role. I know initially the working group and COPRAC decided to limit it to the testifying expert, and that does make it simpler. But at the same time, I do understand the public comments that we should perhaps consider expanding it. It doesn't, or maybe even issuing a subsequent opinion or addendum. I'm not sure, but I do think that addressing a common situation where the lawyer acts in both roles as first a consultant and then a testifying expert would be more useful in providing guidance. So I'll pause, and I just would like to hear others' thoughts on that initial question.
I have a question, Sarah. I guess I'm not sure I understand the distinction between a consulting expert and a testifying expert. I know the distinction, but I think for purposes of this, in my mind, because I am an expert and retained often on ethical issues, I don't distinguish between the two. I'm being retained as an expert. If I'm disclosed, great. Until I'm disclosed, I will provide whatever opinions that are required of the party engaging me for that. So I'm not sure. I didn't read the public comment, unfortunately, so I don't have the background in terms for the basis of the comment. So maybe there's some clarification there that someone could tell me. I just don't see the difference, quite honestly.
Yeah, and I don't know that there was a lot of clarification, and Brandon, you can jump in, but my understanding is, for instance, like there could be a situation where they're engaged and I've seen this happen in practice, where the expert is engaged and it's clear the expert engagement will even say, I may not be disclosed as a testifying expert without my consent, right?
Right.
And the expert is engaged in the consulting role. And as part of that, the expert might be acting as a lawyer, really providing legal advice and strategy to the party engaging them in the underlying litigation. So in that role, they're kind of engaging the practice of law, and it could be construed as an attorney-client relationship. So arguably, the rules of professional conduct might apply to that role,
Well, and I think
versus when they're purely serving as a testifying. And no, I was just saying, I was just going to say versus when they're purely serving as a testifying expert and not at all providing legal advice in the underlying matter. But I'll pause, Brandon, if you want to.
Well, yeah, and a lot of it, I think there's a lot of importance attached to confidentiality, right? The consultants within the privilege and then, but once they are designated, there is no confidentiality. There's no, and then, so that really impacts whether their subsequent conduct could be accessing confidential information. If it's all as a matter of law, not confidential, then that changes the analysis. And Oh, yes.
Yeah, I've always understood the distinction is that there is a distinction between a consultant and a testifying expert, in the sense that as a consultant, you are part of the retaining attorney's work product.
Right.
And when you are designated, you no longer are part of that work product. And in my standard engagement letter, when I contemplate those possibilities, I always remind the retaining attorney in my engagement letter that should I be testifying, then I no longer will have any duty of confidentiality, and everything that has been discussed, including from the initial conversation forward, even before I was designated, becomes discoverable to the other side. And I think that's an important distinction to keep in mind.
Yeah, I think that's actually totally consistent with the what I was trying to describe. And it's also very kind of you to explain that to the litigators that hire you so that they don't make mistakes.
Yeah,
Raquel.
so Joel, just based on what you said, so you would be in favor of, it sounds like, addressing that scenario.
Yeah,
Yeah.
I think it's important.
Yeah, agreed.
So,
Okay.
I see Raquel's hand is up as well.
Yeah, yeah.
Hear Raquel's comment.
I have a question that goes back to the genesis. How did this, it looks like this started in 2020 maybe, is that correct? This opinion based on the numbering?
I think so.
Okay, so I was not here, so I realized, because you're asking us now some nuances, which understanding a little bit more, where did this initiate from in terms of doing this opinion, and what are we trying to solve? So that would be helpful
Those
to
are great
know.
questions.
Should we expand? Should we do number 3? All of that. So
I don't remember the exact genesis of this. This is something that the initial lead drafter is not on our current committee because due to the passage of time. I don't know if that was, I think it was Adam Koss. I don't know if that was,
yeah.
I don't know if it was his idea. I think it might have been. I have some vague recollection. But regardless of the kind of genesis, I do think that it's clear from the public comment process that we've gone through that the public would like us to address the situation now. Like, I think that was pretty clear from reading the public comments, that they feel that this is a common situation. My recollection, Raquel, about kind of the history, I do know that I think COPRAC and the working group that had been working on this throughout the time period, it's been quite some time, I think they tried to limit it to keep it simple to the role of the testifying expert, because when you get into the consultant role and the testifying expert, it gets more complicated. And I think it was trying to keep the opinion short and simple, but in reality, I don't know if that's as practical. And I see Erica is raising her hand. She probably is the best person to answer your question, so I'm going to defer to her.
let me sort of, because I realized maybe I wasn't as clear. Mine is not specifically about the consultant or not. Mine is really, what are we trying to solve? We're trying to clarify the role, I guess, or the requirements if you are a lawyer as an expert, not a lawyer as a lawyer. So I guess that's what I'm really trying to understand, because I think it's not completely clear now as we have been talking about this over some time. What are we trying to solve? What is the problem that this opinion is trying to clarify? That is not completely clear to me.
I would suggest what we're trying to clarify is 2 things. Number one, there is a distinction between a consultant and a testifying expert, particularly regarding the issue of confidentiality and discoverability of the expert's file. The second thing, I think, what I find it's important to keep in mind, the distinction is that by stating that I'm a consultant, I always insist I'm hired as a consultant first. And that allows me to look at the file, triage the issues, and give them a preliminary opinion just straight from the heart, And if they like it, they can designate me. And if they don't, I'm just their work product and they throw me away and someone else might come in. But at least it gives me the opportunity not to have to shade my true opinion about it. And I know I'll always be consistent with my true opinion if it carries through to when I'm a testifying expert.
So I would just add that it also, we're trying to give guidance as to the duties that constrain what an attorney can and cannot do as an expert, because a lot of lawyers who act as expert witnesses also have active law practices, and there are areas of conflict here, and we're trying to address some of them to, assess duties of confidentiality, duties of loyalty. Where are the lines that an attorney, where is an attorney acting as an expert safe? Where are they crossing a line or in ethical trouble? And as Sarah said, the response to this shows that there's a lot of people, there's not a lot of guidance on this. And there's, in the legal community, there are a lot of people that do expert work that want guidance. They don't always agree with where we're headed, right? But, and especially with the question that Sarah hasn't reached yet, we don't even know where we're at. We've got a lot of conflicting thoughts on it. But the idea is to give guidance to attorneys how to provide expert services consistent with all their ethical duties. That's my sense. Erica?
One other thought that I just recall is that I'm constantly, over the course of a litigation, I'll find myself dragged into a telephone conference where the strategic decisions are being made, and I constantly have to say, folks, you don't want me in on this discussion because what you're saying in front of me is going to be discoverable. So I think it's important to remind not just the experts, but the users of experts that there's this distinction, and they've got to keep that in mind.
Sure.
I would concur with that, was the point I was going to make. And to that end, as the lawyer retaining the expert, you never know what notes that expert is taking. You don't know if a voicemail you've left for that expert is being transcribed into an email that becomes part of that expert's file. And so I think it's very easy, especially when it's an expert you've worked with a lot and have a very, personal kind of relationship where you feel comfortable in talking in a less formal way. It's very easy to forget those boundaries and distinctions, and they can really come back and bite you later when suddenly the expert is designated and all of their records are have to be produced. So I concur with Joel's comment strongly that's an important goal of this type of an opinion, and I would agree that we should be expanding the scope under number 1.
All right, great.
Thanks, Elizabeth.
Erica?
And Erica, I see your hand's been raised. So do you want to weigh in?
Yeah, thank you. At this point, I'm not sure I have much other to add, although I will point out that since there is that comment on that you made earlier, Sarah, about how the disqualification portion of the opinion is really meant to educate the public, let's say, about the implications of this. I think that's another reason that would weigh in favor of including this concept, is to perhaps for non-attorneys reading this, for them to and some attorneys as well, to understand the differences that exist between a consulting and testifying expert. As to the question of whether how this opinion came about, I've gone through the past 8 years of of opinion request documents, and it probably wasn't internal because there's no other record of it.
So the only point I would make here is that it's my belief that, especially based on the public comment, that we should expand and address these nuances because it will be more useful. It's just going to be a much more complicated analysis now. I don't think it's, we were obviously, as Sarah pointed out, we tried to keep it narrow over the years so that we could have a statement everyone agrees on that is sort of indisputable and helpful. And I guess the public is telling us in the real world, that path is somewhat unusual, and we need a more expansive opinion to give us that guidance. I tend to think we should do it. It's just going to be a bigger task and a bigger opinion then.
I agree with that in the sense that the things that Joel and Elizabeth and Bill have described are not really out there, right? Those are things that you learn from experience or people trained you to do. But I think it'd be very helpful to have that distinction and those evidentiary distinctions expanded on.
I think it's funny because I know that wasn't the initial thrust of this opinion, but if it has an ancillary benefit as being like a great practice pointer on how not to screw up confidentiality with your expert, that's a bonus, you know.
We go overboard. Like if Joel's my expert, I'm just like, Joel, this is Dan. Call me back. Goodbye.
Yeah.
Nothing.
Don't write anything down.
Don't write anything down. We don't do anything.
You know, Brandon, let me say something about expanding the scope of these opinions. The other day, I was researching a matter, and I went back to some really moldy, oldie LA County Bar Association ethics opinions, and all of them were like 4 paragraphs long. I mean, they were really short. And then thinking about the 1980s, they started becoming 4 pages long. And I was wondering, why can't we go back to being a little more concise? But now I'm understanding the answer to that question. Okay.
Yeah, I love it. I researched an old LACBA opinion. I think it was from like the late 60s or early 70s. And it was, can an attorney-client fee agreement contain whatever term? And it said yes. I was like, oh, all right. It's understandable. I can read it. So, okay, Sarah, I didn't mean to interrupt you. I don't know how.
No, I think that's helpful. And it seems like from everyone who's spoken so far that it makes sense to, revise his opinion to incorporate the role where the lawyer is first engaged as a consultant before serving as a testifying expert. I think we need to address that situation as well. So add another scenario. The other nuance that I had a question for the group, and is just whether the expert is being engaged individually or through the expert's law firm. In my experience, I've seen it done where the expert is being engaged individually, and the law firm is not a party, but I'm just curious if others have had different experiences and feel that we should also address that situation where the expert might be engaged through the law firm.
So in my experience, it has been more often that I'm engaging a lawyer at a law firm and he or she is acting as an expert, but the retainer agreements aren't, distinct from the law firm entity more often than not. I think it's common enough that if we think it makes a difference, if it changes the outcome of any of our ethical thoughts, I hate to just keep adding scenarios, but maybe we should do it. That's my 2 cents.
I mean, when I do my expert work, my firm allows me to do it on my own. And the only connection I have with the firm is to do a conflict check just to make sure there is no issue there. And then outside of that, nothing comes out of the firm. It's all my stuff. But I do think if you're engaging the firm, then that's a different analysis, I think. And that really is going to trigger more of the conflicts issues or potential conflicts issues when you're engaged in, because basically you're engaging the firm. And now if the firm is adverse to the, other side, then you're definitely talking the 1.7 issue, certainly. I think it's a little murkier when you do it individually on your own. And, like in my instance, and you run in a conflicts check just to make sure there's nothing there. It is different. I mean, again, kind of like what you're saying, Brandon, probably should add a little bit about this to show a distinction, if any. I mean, if there's a conclusion that there is a distinction, that it's probably something that should be done. Because I think your experiences is like mine. Even as litigator, I don't hire the firm. I usually hire the expert, or the lawyer. Not necessarily the firm.
Yeah, when I was working at a firm and started doing expert witness work, well, first of all, I don't think I've really ever seen where a firm is hired. It usually is the expert.
Yeah.
But when I was with the firm, I was hired as an individual. I gave my opinion as an individual, not on behalf of the firm, or it wasn't signed by the firm, if you will. But our compensation system was such that the income I derived was considered, even though I would argue loudly long that it wasn't the practice of law and I was entitled to keep all my income. The way the firm worked, I was contractually obligated to account to the firm for that income, and my allocation of profits from the firm was based upon that production number. And so even though you're not hiring the firm, you still have to think about what are the ethical requirements as if the firm had been hired, including disclosures and confidentiality things. And I can't recall a situation where that ever came up where I was called on to have to deal with it by anybody, but conceivably, that's always there.
So I'd like to thank you, Joel, for adding 2 pages to our next draft. Because you're absolutely right.
As long as you're writing them, Brandon, I can keep adding.
No, but you're absolutely right, because it's sort of a distinction without a difference whether the engagement agreement has one person's name on it or the firm. If the money is commingled and part of the profits, I think it has to be looked at, or at least otherwise we're adding these artificial lines, which is not serving any
It doesn't necessarily make it more complicated, though. I mean, the scenario that Joel just described means there isn't really a big distinction between whether you're retained individually or whether you're retained at the firm, right? So the partnership agreements that we draft or deal with basically say, unless you're like delivering newspapers or shoveling driveways, the firm gets this money. We get access to this. So there's always that financial component to it.
So we need to look at that. I mean,
even if there weren't the component, though, there would be the ethics, or maybe not conflicts issues per se, but the confidentiality issues.
I don't think the conflicts issues are very different whether you're outside or inside, right? I think, and as everyone has said, you still have to look at the conflicts. I think then the confidentiality questions might be different, but not really.
Would the imputation be the same, I guess would be my question. And I don't know, I haven't thought about it, but I'm wondering if the analysis of imputation would be any different.
Technically, maybe.
I think the guidance, some guidance might come from the body of law that talks about what happens when a law partner is a director of a corporation or that sort of thing. And I'm just speculating that you might find some guidance there.
Firm also wants that money too, by the way.
Yeah, right. Sensing a theme with these firms.
We at least want to look at the money. We'll tell you whether we're going to keep it or not.
Right.
There might be exceptions made, but we'll have the right to it.
Right.
Well, I mean, does anyone disagree? Does anyone say, no, keep it narrow as is, or does everyone sort of think we should address all these issues we're talking about?
I mean, I think we ought to address these issues. I mean, the public wants to hear about it. I think we ought to, because there are a lot of people who don't do expert work all the time and may be considering expert work and just not, know the thicket that they may be encountering if they decide to do so. So I'm for explaining all these issues. I mean, it makes sense to me.
Okay.
I would also say include them. Let me not say explain. I think include them. I don't think, based on what I've heard, that it needs, that now it's 10 pages longer. So in some way, I do think as I look at how we're doing things, just not particularly this one, but all of them, as Joel said, they're getting longer and longer. And I don't know that that's automatically necessary. So in some way, I think it's how we're making them longer by how we're thinking about, we need to add all this case law and explanation and et cetera, et cetera. And by the time we're done, they're just becoming so voluminous. And the issue with that is that people aren't going to read them, right? And so if the opinion is to give guidance so people can behave in a certain way, we're going against our own intent if we're making them so long that people have an intent, like they want to read them and they say, I'll get back to them, but they never get back to them. And so we're doing work that's not being helpful. It's helpful to a small group of people who read it, but to the people who really need it, probably they're not reading it. And so I think that's what we need to figure out how to solve for, because over X number of pages, people just don't read. And as we think of younger people, their attention span automatically is much different than those of us on this call. Like if it's not in a bite, they just don't deal with it, attorneys or not. And so to me, so I don't know what the magic number is, but I just do think I don't hear 4 or 5 more pages added from what I heard on going around and around on the call. But I think we could easily make it 4 or 5 more pages.
Raquel, you're raising an excellent point that we should consider globally. Is there something to be done? Should we putting more time and focus into more robust digests or summaries, and then the following 8 pages are here's our analysis, here's how we got here? Because I have heard, like, the only universal complaint I hear about COPRAC opinions is not that they're wrong, it's that they're really dense, and people in a time crunch trying to figure out what they can or can't do get really frustrated. Now, it's tough because I think one of the great benefits COPRAC provides is our analysis. Here's our thinking. We're not just saying yes, no, we're not doing that. But I wonder if we can front load the digests a little more helpfully. It's something to think about going forward, because Raquel's observation is something I've heard from practitioners. So, Joel?
Yeah, I'm not sure I would agree with your word robust. I think the approach on the digest ought to be a lot more concise but clear. And I think it would be really helpful to have on the first page what the question or questions is and what the quick answer is. And after that, I think the length will be helpful to those who are interested in a particular part of it, and it can be ignored by the rest who aren't. So I think it's just working on getting the first page of this thing that really answers the question, yes, no, yes, yes. And then you look at that section if you're interested.
Mm-hmm. Bill?
Yeah, I agree with both what Jill said and what you're saying, Brandon, is that, and when you were talking, I was thinking of, just looking up a case on Westlaw. You have the head notes that are very concise and hit the issues in the opinion, and thinking about what Raquel's saying, the length of opinions. If we have clear, concise issues in the digest, one who's looking for some guidance can say, okay, this is going to talk about 4 issues. Oh, that's the one I want to talk about, or I'm interested in. Boom, they can go to it, easily. So I think a clear kind of issue, laying out the issue clearly in that digest up front is extremely helpful. And, if it means it may be a little longer than we like, to make sure that people understand what the opinion is about, I'm for that. I think up front loading it is a good idea.
I think the goal ought to be that we scrutinize the first page to make sure that every opinion that we issue asks the questions and gives the short answers.
Yeah.
And after that, I don't care so much about the length. And in fact, I think that getting into the details sometimes is helpful to the practitioner who's really looking for that guidance for their particular case. So, but the front page, the first page, is really what we ought to be scrutinizing and editing and making sure we're being concise and using the correct words and not being namby-pamby about, well, kind of, maybe, but give some real clear guidance. And if the front page can do that and answer, okay, is this going to help me or not? And if that does that, then the length after that, I think can only be helpful, really, unless it's just surplusage.
Got it. Dan,
I'm very much in favor of shorter opinions, and they can be more concise when they're shorter. And the thing that I think we should potentially consider during moments like this is whether this should just be split. Right. There are definitely values to defining the difference between consulting and testifying. The conflicts question is almost its own thing, and they're related, obviously, but it doesn't have to be a treatise about expert work. They're specific questions. it could be split into two that are fewer than 10. There may be 6 or 7 pages each. And if you're looking for the evidentiary and confidentiality issues, you look at the one. And if you're looking for conflicts analysis, you look at the other one. They're obviously related. But I don't think we should, I'm not have an arbitrary rule, but if we're going over 10 pages in an opinion, it's probably just got too much in it.
We'll do the expert witness trilogy. It'll be pretty exciting, I think.
Yeah, that's right. Well, Lord of the Rings, same thing. It was long, but everyone loved it.
All right.
I recall.
I tend to agree with you, Dan, because we are actually at this opinion already at 10 pages. And I thought about that too. And that's what I raised initially, like, I think this should potentially be a separate opinion or like a part 2 to this opinion to address, because I think it's going to take, right now, even though it's at 10 pages, we haven't yet addressed the second question that the working group had, which will likely expand our discussion in scenario 3. So I think for that reason, it probably does make more sense to address this consulting role in a second opinion.
I think that particular one has real value in the sense that I don't see a lot of other authority out there or places where people can get that guidance. So,
and Erica,
I don't know. Go ahead, Sarah.
Oh, I just saw Erica had her hand raised. That's all I was saying.
Well, I was going to say the value of putting them, and you can put them both out for public comment, and then you have all the commenters who said you didn't consider this, you didn't consider that. They'll have both to look at and weigh in on as well, and you'll get the whole feedback or analysis from those commenters to address all of these considerations, and then hopefully you won't have the situation that you're currently in with considering expanding because they don't think it touched them enough.
Yeah, I don't know if it was by design or not, but I recall maybe 20 years ago there was a trilogy of COPRAC opinions about handling trust funds, and they were split up. They all issued at the same time, but they kind of split up the topic in terms of could you take payments by credit cards was one, and what did you have to put in your trust account and not was another. But they all came out at the same time, and I don't see any problem with doing that either.
Okay. Well, Sarah, is this a good segue into you leading into the next puzzle?
Yeah, I think that makes sense. And my only other question that I had is just, you had raised the question initially, I hadn't gotten a chance to weigh in response to your question about, like, does anyone think differently on the second question, not about addressing the nuance of the expert being engaged individually or through the expert's law firm? And then I guess adding to that Joel's comment about even if they're engaged individually, the fact that the compensation of the expert will be shared with the law firm. I feel that from what I'm hearing, and that it's if the role of I think the expert is typically engaged individually, so I'm not sure we need to address the nuance if that's not a common situation where they're being retained through the law firm. I think that would be much less common, but
Sarah, I think you're right, but I wonder if we should revisit or just think about we've been viewing the expert as being retained individually as helping distance that expert from imputation and conflicts. We should think about the commingling of the comp and the money and whether that undermines that thinking. Yeah.
That makes sense, and I agree. So I'll move on to the other question that the working group had, which is, this is particular to scenario 3, which is where the lawyer is concurrently serving as a testifying expert. At the same time, the law firm is representing the adverse party in an unrelated matter. And I think I might let Brandon, you take the lead on this question, but I mean, this was basically a lot of the public comments felt that there was not enough discussion in this scenario 3 analysis of the duty of loyalty owed by all lawyers to the law firm and to the client.
Right.
And so,
and I'm happy to share my thoughts, because we've been talking about scenario 3, and now I'm going to blank on the facts. Whether is the expert testifying against the firm's client, or is I think that's what it is, right? Expert testifying against the client of the firm, but in an unrelated matter. Oh, Sarah, you're quiet. You're muted. I can't hear you. I can't hear you, Sarah. I don't know what happened. Can anyone hear me?
Looks like she's muted.
Oh, I guess you're muted.
Oh, sorry. Can you hear me now?
Yes.
Okay, so I thought I hit unmute. But the expert is retained as a testifying expert whose testimony will be adverse to a company who's a current client of the law firm
Right.
in
Okay.
an unrelated matter.
Right. And so the current iteration that's gone out for public comment found this to be permissible. This is acceptable. And a lot of folks reacted saying that that's disloyal. And, you know, we've looked at over the years, tried to square Oasis West, which is, I think, the only hook I'm trying to hang my hat on, because I'm deeply uncomfortable with this idea. I think
Me
it
too.
violates the general duty of loyalty. And I don't think you can do it. And I would never do it. I'm sure none of us would ever actually do it. So I'm really concerned, you know, our last draft said you could do it. And it's hard to find any authorities directly on points for why this is absolutely impermissible, unless we go to a broader duty of loyalty imputed to the expert that would prohibit the expert from undertaking this engagement. And I'm comfortable doing that personally, but it is not what we usually do. We are usually pointing to rules, statutes, cases that say why you can or can't do things. And we are talking a little more generally. And again, I just want to say, like, there's probably a lot of research that I haven't done here. I haven't looked at like the roots of the duty of loyalty and every case and how it expands. But we really want to get the sense of the committee here. I actually voted against this opinion previously just on this issue. And I just want to see where everybody else sits so we figure out how to attack this. Where are we going with it? And what?
Yeah, and just I just want to add a little bit quickly to what Brandon said, just so everyone, if you haven't looked at the public comments recently, has an understanding of what the public comments were on this particular issue. And I think some of the public comments from the bar associations thought that while we might be right in the conclusion reached in scenario 3, we need additional analysis and at least discussion of the duty of loyalty. Because I think, like we as COPRAC, the working group, and COPRAC, the full committee, has struggled with this scenario 3. I think a lot of the issues involving a situation where they found that there would be a conflict involved, a situation where the expert, there's a similar matter, or somehow there's a risk of disclosure of confidential information, which is what Oasis involved, or you're really attacking the work you previously did, where it doesn't, our scenario 3 doesn't fit into those situations, which I think, which is why some of the public comments didn't necessarily disagree with the conclusion we reached. I mean, some expressed, there was at least 1 or 2 that expressed some concerns, but I think the bottom line is, even if we don't change the analysis, which I think we should consider, is we just need to expand the discussion of the duty of loyalty at least.
You know, I've dealt with this issue a couple times now, where I'm defending a legal malpractice case, and the opposing expert is my former client. And I know on at least one of those occasions, we tried to disqualify the expert and say, look, I can't cross-examine this guy because I have confidential information that I could arguably use against him as the opposing expert in this case. And so we tried to disqualify the expert, and the court denied it. So that doesn't even square with Oasis. I mean, it seems under Oasis, that would be a situation where someone has to get disqualified. Either my firm has to get disqualified, or the expert has to get disqualified. And it seems in that scenario, it probably is easier to have the expert disqualified and get another expert than the firm who's been, defending the lawsuit for probably at that point 2 years by now. But I just thought that was interesting because it creates a quandary for me as the lawyer. I have information, obviously, that I can't disclose about this expert that would go to that expert's credibility. and, and I'm hamstrung, and then the court says, well, I'm not going to disqualify the expert, then what are you going to do? Right. So it's an interesting issue. And I thought one that was easy, it seemed easy. I thought it was a no-brainer that the court would say, yeah, you're right, go get another expert. And that wasn't the case. On 2 occasions that happened.
Two comments. Brandon and Sarah, I recall there was a Shell Oil case involving a lawyer from Shepherd Mullen. Oh, we're talking maybe 15 years ago, where that came up, where a Shepherd Mullen partner was testifying against a Shepherd Mullen client.
Yeah.
And there might be some guidance in that case.
Are you talking about American Airlines, Joel?
Yeah, that's the one.
That's the American
Okay.
Airlines case.
If you've looked at that, fine. Then the other comment I'll make is just a practical situation where, what do you say to your partner who comes to you and say, you SOB, your testimony screwed my client and he fired me? So that's just a business thing, but it's something that's got to be considered.
Well, that's part of one of the things that came to my mind is, besides the compensation, you do have a fiduciary duty if you're a partner, right? There's that. It's not just a business thing. It's an actual possible conflict to an obligation that you owe to the firm. But then I think, I was hostile toward this conclusion. I think I voted against it for that reason. But I also feel like if we reach a conclusion like this that I would never advise one of my clients to do, it makes me wonder whether there's something else missing. And I think it is the duty of loyalty. The practical things that Bill described, I think, are also top of my mind. If I were deposing an expert who had this, we would spend probably a day talking about how he or she gets paid, where the money comes from, what part of that matter at the firm he's or she is getting, what kind of confidentiality restrictions have been in place, whether they were ever breached, all those types of practical things that would be big waste of time for everybody, mostly the client who hired the expert. So I'm working back from the conclusion that doesn't make any sense to my mind and thinking like there must be something else.
Well, I'm not sure where
Drop the mic on that one.
Yeah, no, it's good. I mean, this is a real challenge. This is a real challenge because I don't is anyone comfortable? And I'm not talking about ethical analysis and the legal analysis being correct. Is anyone comfortable with the idea of an expert testifying against a current client of that expert's law firm, even on an unrelated matter? Because I want to probe that discomfort. Like we all practice in this space, and it's striking most of us as this is not right. And I think that should guide us in some fashion to more research, to a different approach, something like that.
I think it depends on how big your firm is. I mean, the New York office who has a client that I don't care about is not, I mean, like
you have
that,
a duty to care is one question.
You care as a matter of law. Yes.
Yeah. So, I mean, that, like, I'm conflicted over my comfort level, but I think it depends on how big your law firm is, the degree of discomfort. We're not talking about duties. We're just talking about comfort level. That's my response there.
Okay.
How did we analyze the duty the first time around? Like, did we dig into this at all?
Well, I think we went by the rules very strictly and found this not to be prohibited by the rules. If you look at
Because you're not representing the other client.
Right. If you look at 107, it falls outside of it. And even when you look at Oasis West West was the same subject matter. And so we've distinguished it here. And on that read, I think that's the correct outcome. There might just be a different ethical duty or a broader ethical duty that we are not addressing.
And I'll just add the other thing that I think scenario 3 does address, kind of this other federal court case, which has a similar factual situation and found that there was no conflict in that situation. But I think it was like a Seventh Circuit, or it wasn't the Ninth Circuit case. And so that was the other opinion that was relied on. There's a lot of unpublished case law and stuff. Like if you go on Free Google, I mispronounced his name, but on ethics, he has a whole section on like lawyers as testifying experts. And if you look at a lot of those cases that are cited, it just seems like where there is a conflict, the matters are related or there's a risk of confidential information. Although I share everyone's concern with the discomfort here and the concern of the duty of loyalty. And I just wish there were a, maybe more research can be done, but an authority on point that addressed this particular situation.
You're the authority, Sarah.
We're going to cite to Sarah.
I'm interested in digging into this too. I'm not as uncomfortable, I think, as the group. But I think it's worth digging into. Have we looked at, is like rule 1.8.1 business transactions adverse? Does that not impute? Is that why that's not an issue in the analysis?
I don't think that if it's the expert who's adverse to the client, I don't think 1.8.1 applies.
Because it's not imputed. Is that the idea? The duty not to.
Who has?
I don't know that it's a business transaction.
Yeah, who has the business transaction with the client?
Adverse to a client, right? So would it?
Oh, I see what you're saying.
Apply?
I get what you're saying. Interesting. Wow, I'd never.
That's a very good point, right?
That's definitely an ethics nerd issue the average practitioner is not going to think about.
Yes, and that's why it's so fascinating.
Yeah. Very good point. Yeah.
It does match up with the intuitive thing, which is you're getting paid
right
for something that's against this paying client's interest, right?
Yeah.
Yeah.
I don't know that it imputes, or if it falls into that kind of personal interest type issue that wouldn't impute across the firm. And that might lead into an analysis of what, whether it should impute or shouldn't impute.
Well, would it,
who's getting paid, how the money goes, like, I don't know. It's just worth thinking about.
That's really interesting.
But thinking about that, if it were considered a business transaction, who would you be describing the terms of the transaction to? The lawyer that retains you, or the client against whom you're adverse? And if it's the latter, then you're running into a confidentiality issue that we talked about earlier. Is it a consulting expert? Is it a retained expert? It seems like you run into all kinds of.
That's why we're not doing it. We're not advocating anybody do it. Right?
Right.
It's just not make any
My
sense.
guess is that this doesn't impute across the firm, but I think that would be called into question if the money were going to the firm potentially. I think it's not truly personal then. So, is it a personal conflict or not? So if a firm allows somebody to engage as an ethics, an expert, but isn't accepting the money, it would seem a clearer case than when the firm is being paid.
This is a really creative application of 1.8.1. It's really fascinating. I have never, it might square up. It's very.
The money is also going two ways. Like the expert, if he or she is a partner at the firm, is getting paid in part based on that matter.
You're getting money from the client and money from being against the client.
Right.
Yeah.
Interesting. All right.
Look at.
It's nice work if you can get it, but.
But if you look at those cases, which talks about setting up your ethical screen and what you're supposed to do to isolate the partner to prevent a imputation, one of them is they can't share in the income. And if that's a factor to augur in favor of imputation, then the fact that the expert is sharing the income with the firm may be more relevant than we're thinking.
So now my expert discovery includes that expert's partnership agreement, and I guarantee it says they're entitled to consider getting some of that money. Yeah.
Right. Well, it serves anyone right who takes both sides of the issue. Like, well, anyhow. That's my editorializing. But this is a really interesting approach. We should
Well, if you look at, I don't know, the comment 1 to 1.8.1, I mean, it seems to fit. The lawyer has an other pecuniary interest adverse to a client within the meaning of this rule when the lawyer possesses a legal right to significantly impair or prejudice the client's rights or interests without court action.
that's like a right to foreclose though, right? Like a possessory interest or
Yeah, I think so.
Yeah, that's the example given.
I mean, it's more of a direct, some more direct bit transaction with the client than. Yeah, I'm not sure if it fits as a business transaction. I mean, you have to kind of enter, the transaction has to be, well, I don't know. I said the transaction has to be, involve the client in some way. And I guess it does here by virtue of the litigation, but there's no transaction in
Well, it
connection with.
does. I
Yeah.
mean, if you
There is
read
a
it,
transaction.
Yeah,
It's,
yeah, I know, but it's not, the client's not a party to the transaction or.
Well, but
but
it's an
I-
interest adverse to a client.
Say that again? It's a what?
I'm quoting C. Mercado et al. It's an interest adverse to a client.
Yeah, I know. I'm just trying to think of other examples where it's this attenuated, where it would still exist.
we're going to get an angry letter from each member of the Rules Revision Commission saying that we have,
Dredge the
gone astray
interpretation.
or something. Yeah.
And they can explain why this would be okay. They can tell
Right.
us.
Yes. I'd like to have a two-way conversation.
I mean,
Well, this is interesting. I'm not sure it is the answer, but I think it is worth some analysis. And do we have a general sense from so there's really kind of two ways I was looking at it. One is, are we confident saying you cannot do this in scenario 3? Or if we're not that confident, are we sure that we just don't want to be saying it's okay? Because that's where I'm 100% sure. I don't want to be supporting an opinion that says, yeah, go ahead, this is fine. Even if I can't put my thumb on exactly why it's wrong, I don't think the world needs us saying, yeah, go for it. That's my 2 cents. But I just would love to know what other people think. Should we be looking for the legal support for our intuition that you shouldn't do this? Is that the next step here?
I'm not sure I share the intuition that we shouldn't do it. I think it's fraud. Even I share that. I'm not sure that it's you should not.
I think it's really interesting because I think you came up with the most creative path towards no.
Eleanor, would you do it?
Yeah.
Would you do it?
Would I do it? Probably not. No.
Why?
Because I feel uncomfortable about it. But I'm not sure it's
Go
a
on.
violation of the rules. I just don't think it's worth doing. But I think you could have a situation under the rules where you have somebody who's, quote, not practicing, they're serving as an expert, they're not sharing an income, so it wouldn't be personally, taking an interest adverse to a client. I'm not sure 1.81 imputes. And they don't have confidential information. I can share, I can create walls that maybe the information isn't even stored at the firm and the firm is not receiving compensation. I think under those circumstances, I start to get a little more comfortable. And I'm not, I haven't thought this through. I'm just talking on the fly, but.
Yeah, I think and part of the hesitation that I have is that practically all those things in one situation are extremely unlikely.
I don't know about that.
Well, once we put this opinion out there, there might be a lot of revisions to how experts do their work. I don't know.
I feel like if this expert issue went to litigation, it would be like the ultimate battle of the experts to give an opinion on this particular issue.
Very
You have
meta.
people
You'd be
very
impeaching their
passionate on both
credibility.
sides. Yeah.
Yeah.
You could find plenty of people on both sides of that, I think.
I'm thinking about it from a big firm perspective, and I haven't dealt with it a lot, but I think a lot of larger firms would be very happy to let soon to be retiring people, go ahead and start an expert practice as they're retired. Like that type of situation to me seems pretty reasonable And in those circumstances, they wouldn't necessarily want the funds. They, you know, they would say, keep it off the firm's systems. We're going to wall you from anything, etc. You know, why anyone would want to do this for business reasons, I don't know, right? But I could see somebody getting their head around it ethically.
Okay. Well, I think our trilogy is going to need a bigger budget and more horsepower. I think we should empower Sarah to involuntarily deputize people to help on aspects of, because it's a lot of work. We're talking about a lot of outlining and a
I
lot
like
of,
your management style, Brandon.
yes, yes.
You're getting
We're
your
doing
leg
tough,
here.
but I'm not the one who has to do it. I'm trying to make it Sarah's bold moves. Because I do think we need, I just, you know, this has been incredibly helpful to hear everyone's thinking, but I think it's a lot of work. So
Yeah, here, one thing I think I propose, and I think just to move this forward is, I think the second question that we're addressing, I think it's clearly worth further analysis and maybe an outline of how we could address the duty of loyalty, and also considering Eleanor's creative suggestion about addressing, you know, considering potentially the application of Rule 1.8.1. And that would be something that I think would be part of the revision to this opinion. But I'm in favor of it, and I don't know that we've heard enough from everyone. I know Dan weighed in on this, but about whether the other issue, which I think is going to take more time, is just addressing the situation where the lawyer is first a consultant and then a testifying expert. And then the nuance we address in terms of, even if the lawyer is engaged individually, the fees the expert gets are shared with other members of the firm. I think that is more appropriate for another opinion or a part 2 of this opinion. And I think starting off with just an outline of that makes the most sense. And since it's a new opinion, I guess I wouldn't necessarily be on that working group.
Nicely done.
But no, I do think we should get maybe even if others agree with that kind of approach to tackle this, maybe it makes sense to get a working group on the consult, you know, the first issue, and a working group on this. I mean, we already have a working group on the current draft opinion with scenario 3, but I think that's just, is it Brandon, are you on it, or did you just fall? I think Brandon,
I don't
Joel,
remember,
and I.
but I've been bothering you guys. So yeah, I'm either on it or an uninvited guest, but
I think it's Brandon, Joel, and I currently on that, but I think it would be great to have another volunteer for that, you know, just addressing this duty of loyalty issue, for scenario 3.
I'll be happy to volunteer. I've been obviously running my mouth about it for long enough. I can't really avoid it at this point.
Great. And then before we get into the consultant then expert, does anyone think it should be part of this opinion? Maybe I'll ask it that way.
You know, I almost think it really depends. We should spend a little bit of time researching it, because if it might be not as brutal outcome determinative or anything like that. I'm not sure. I don't know how big it would be. And if it can tuck into this opinion without making it huge, great. But do we think it's going to be pretty expansive? I might be misjudging how deep it goes.
It might not be, but I still think it'll be at least maybe a page. And for that, just because we're already at 10, actually, I think we're going to be over 10 pages now, and with the expansion of scenario 3, it will be even longer. So, but we can do that. We can decide later, I guess, like you're saying, Brandon, and just get the outline in place first, and then decide based on the outline.
Why don't we get a working group to start working on an outline for that, and then we can decide, like, oh, that's ridiculous, that can't go into an existing opinion, or whether it can. So who's on the long list of volunteers for the new working group on this issue of consulting versus testifying experts? I think my audio malfunctioned, guys.
I'd be happy to be on it, but since I do act as an expert, I feel like I'm somewhat interested in the opinion. If no one has an issue with that, I'm happy to be
I
part
hope
of
that doesn't matter because I've been talking this whole time and I do expert work, so I should have.
I think
disclosed
that's
it.
helpful to
I think
actually.
it's
Yeah.
All right. So
Happy
Bill,
to do it.
great. Anyone else? Somebody else.
Folks from the existing committee, I think should, an overlap would be good, I think.
Well,
I'm okay
be
doing
on-
both. I'm okay
I'll be
doing
on-
both.
Yeah. Well, I'll be on this group. Dan, are you volunteering?
Yeah,
Or-
I'll
okay.
do
Okay.
that.
And then Elizabeth, do you still want to volunteer?
Yeah, I'll help out.
Great. Great.
Sorry, just to be, that was Brandon, Elizabeth, Bill, and Dan.
Yeah.
Eleanor, I saw you.
I did.
Oh, okay, great. It's huge. I'm gonna quit this working group because it doesn't. I'll just poke around as the uninvited guest again.
All right. So
And
just for clarity, what is that working group compared to the other thing?
It's going to be outlining the differences, the relevant issues and potential outcome determinative differences between someone who's only a testifying expert or someone who's a consulting expert or someone who bleeds from one to the other, and how much that impacts any of the other conclusions we're reaching.
And do you think we should wait for the first group to do their work to kind of determine whether or not it's actually going to stay separate?
So I can't, that's a great question because it's sort of this chicken and egg thing. Because can we even do the first opinion without, like, what would our approach be? We're just going to ignore the consulting thing for now. I'm not sure how we proceed until this all fits together.
I mean, the first group could give it some thought and then just expand to encompass make it a bigger group and start assigning things, I suppose. But I'm not sure it's going to work without it. Maybe it will. Yeah.
Right.
Yeah.
The consulting distinction is going to, I think, be relevant to the confidentiality issues and a lot of crossover. So maybe you ought to work on them simultaneously.
I'll just say the challenge you are going to have is Bagley Keene. So these two groups can't overlap, or they can overlap, but they can't really cross share too much. You're going to have a Bagley Keene issue. So that may be you've got. I don't recall off the top of my head who's on the working group for this one, but you have 5 proposed for the new working group.
And what's the magic number?
Yeah.
7's too many. You have 1 more. So.
Got it.
If we have too many, I can just go off because I'm on the other one. So I have no problem with that.
But the problem is that we thought the crossover was beneficial. It's tough. All right.
So Erica, there's only 4 on the consultant as expert, consulting expert.
Who is that? No,
I withdrew. I'm out of it. I'm out.
Because
out.
Brandon,
Okay.
Brandon got out. Yeah.
Okay, and then
I don't know if it changes, but there's only
Dan, you're the crossover, and then who else is on the current for the 20-0001? That's Sarah,
Me, and Joel.
And Dan, I thought, no.
Oh yeah, and Dan. He just joined. So he's the
5.
Yeah, that's 7 total.
Oh, that's too many. Okay.
I'm happy to withdraw. I mean, I'll do whatever is useful to the group. I don't feel a need. I'm interested, but I don't feel a need to do it. So if it's helpful for someone to step back, I will offer to step back in if you segregate them. I mean, whatever works.
Why does that work, Erica?
Yeah, the only issue is if you guys want to communicate with each other, that's the issue here, or share information across them, because it creates the like a serial meeting essentially. Is
Dan problem. Dan's automatically violating if he talks to one of us about what's going on in the other one.
If right? There's more, if they
violating so many things right now.
Between the two,
the conflict of interest.
Yes.
Yeah. Can you explain a little bit about the rule? I'm not sure I'm appreciating the issue fully.
Yes. So Bagley Keene requires a noticed meeting where there is activity of a appointed group, which is why we use volunteers, or a quorum. And the way to create a quorum without creating a quorum is by doing either a serial meeting. So it's 3 people meet and then one of those people communicates with 4 others, essentially. That would mean 7 have the same information and it constitutes a quorum. And that's the concern here, essentially, is that it would be the majority of members communicating about an issue outside of a notice meeting.
Got it.
Let me just throw in that what do I have? 3 more meetings and then I'm out, and I might as well be out on this committee, this issue now. I haven't been contributing that much, and it'll just take the pressure off. And besides, as Brandon knows, the hill I'm going to die on is the conversion clause thing anyway. So I think
Withdraw from that one instead.
take me off the this expert thing, and I'll just I have I'm going to pass along my standard engagement letter to Brandon and Sarah, and I have a couple of template engagement letters I've collected from other people and for expert work, and I'll pass those along, and then I'll do adios to this opinion or opinions.
Okay, that makes sense.
All right.
So then we only have 3 on each, so we're good, is that right?
You have 4 on the new one and 3 on the current one, but Dan is the crossover, and that's less than 7, so we're okay.
Oh, okay, perfect.
Who's the 4 on the new one?
Elizabeth, Bill, Eleanor, Dan is who I
Okay.
had.
So Eleanor can stay on. Okay.
Correct. And then Sarah, Dan, Brandon remain on 20-0001.
Okay, perfect.
We should form a working group to talk about how exciting Bagley Keene has made things. All right.
That's old news at this. I think that's what we're at 7 or 8 years at this
Yeah,
point.
it's been a while.
Addressing it, yeah.
Okay, so is this our lunch break time? Is this a good-
It can be. This one went longer than I think anticipated. So it can either be lunch or there was the flat fee opinion. It just depends on what the group would like to do.
The flat fee opinion is the only other substantive opinion we're going through today, right?
The only other opinion that's drafted. Then there's also consideration of the changes to ABA Model Rule 1.16, the opinion outline regarding the lawyer assistance for abortion related services that was described in the public comment this morning, and that should do it. And then a few short announcements at the end from me.
Okay, I would suggest we break for lunch now unless anyone feels otherwise. Okay, should we come back at 1:45 or 1 o'clock? Do people have things they need to attend to, or can we do?
So I had made lunch plans for around noon, so I might be late coming back because we have a new associate starting in our firm today. So I probably can't come back until 1, but that's fine. You can go on without me. I don't impact the quorum. So
Okay, so let's enjoy your lunch plans, but let's try to get back at 12:45. All right.
Okay, Brandon and team, I'm going to join by phone only after.
Okay.
I'm
great.
going to be in transit. Okay,
All right.
thank you.
Thank you all.
Bye. Okay,
thanks
thanks.
everyone.
Now.
Well, I hope everyone had a lovely lunch. And thank you for returning. So we're going to start, Joel, with your revisions to your draft opinion on flat fees. So if you'd like to walk us through a little bit of what's new in your draft, we can chat about it.
Well, okay. The only thing that's new is just wordsmithing. This all started with Ken's work, and I picked it up a couple of months ago after he went off, and I really didn't change any of the content of the, just more wordsmithing than anything else. And I was just looking at the digest, and I think I followed my own advice. I think we've got what the issue is, and what the digest says, all in the first half page. So I really don't have much more to add.
Okay. So I thought these revisions were great, and I think the draft's coming along really well. My only concern or area of questioning is, I think section B, where we talk about determining when a flat fee is earned and in what amounts. I think the opinion accurately spells out what is non-controversial, but I'm not sure it quite answers us. Oh, that's not what I meant. Where am I? What section of this draft? Sorry. I'm not sure we have an answer or are communicating an answer about how, when is a flat fee earned? I guess it's on page 4, bottom of page 4, that section B. I think it's still pretty unclear, and maybe that's because we don't have answers. You know, how do you earn how do you determine the quantum merit value of a flat fee that's not fully completed? I have heard people say over the years that they believe unless you fully complete the flat fee is not earned. You know, the agreement was for a task to be performed at this price, and it wasn't performed. I'm not sure that's the right opinion, but we're not really getting into much of that. And I just wanted to hear everyone's thoughts on whether we should get into that. Can we be of more use, or are we saying all that can be said right now? Let me.
Well, I think this is pretty much all that we can say right now. What's the rule? 1.15, I think. I don't think gave us that precise guidance, but flat fee advance shall be deposited or not, unless you have an agreement in writing. And it just says any flat fee. So I think it depends on how the parties in their agreement define what the flat fee is being paid for.
Right.
In other words, if you say, I will pay you a flat fee of $1,000 for task A, $1,000 for task B, $1,000 for task C, it's a pretty simple question. If you say, I will pay you $3,000 for A, B, C, then if the parties don't have an agreement as to what A, B, and C are each worth, then you go to the reasonable value analysis, because however you characterize it, some portion of the flat fee is not earned. And since 1.15 is pretty squishy about, you know, whether it goes into the trust account or the operating account, all that kind of stuff, there really isn't much difference. I think the only real conclusion you can draw based on the current state of the law is that you earn it when you do it. And the part that you do, you earn, and the part that you don't, you don't. But yeah. Ken and I had discussed that some time ago, and neither of us found any authority somewhere else or in California case law which defines that.
That's my recollection as well, and I was just wondering if we had found anything, if we think there's anything more helpful that we can say. But if the state of the law is it's just going to be a quantum merit analysis based upon the work done, the tasks, and the contract, then that is what it is, and that's fine. that's fine.
Yeah, and I don't think that does too much damage, given the concept that the whole flat fee issue, where the money goes, is a matter of contract between the parties, and it can be modified, including whether it's deposited in the trust account and the general account, how it can be earned, and everything else. I don't think that just saying, if they forget to do all that, you use a reasonable value calculation as best you can to determine what has not been earned. It has to be refunded.
All right. That was my only real consideration. I would love to hear what others, if they have suggestions or revisions. I mean, what stage are we at with this, Erica? Would this be the first? It's never gone out for public comment, right?
I don't believe so. Let me double check real quick.
No, I know it hasn't, because the draft I got from Ken to start my work clearly reflected that it was not public comment ready.
Got it. I mean, I see some typos and things, but that's of no real consequence. We can clean that up.
Yeah.
Joel, did you want to try to vote this out for public comment today?
Yeah, I think it's ready, and it's not that controversial. If somebody's got some comments or even some suggestions on how they think the flat fee should be earned, let's hear it.
Everyone's still sleepy from lunch.
How
Look,
do you want to do it? Like, Brandon, you say you got some typos and stuff. I tried to eliminate those, but in my imperfect way, I obviously didn't. So if you've got them, do you want to just shoot them to me, and I'll get another draft to give them to Erica? And
yeah, I mean, I think we can, Erica, correct me if I'm wrong. We could approve this for public comment as to substance, subject to minor, typo cleanup by staff, and then we can both tell staff and not take the committee's time with that,
Yeah, that's absolutely right. I mean, we generally, if there's a typo, we're going to change it anyway,
Yeah.
Regardless of whether or not it's voted to do so, especially at the public comment phase. But that would be helpful if staff can make, non-substantive clarifying edits and grammatical typo edits as well.
That sounds good to me. And it really is a very quiet post-lunchtime committee. So I think unless somebody's going to interrupt me, I'm going to move that we vote this for public comment with staff ability to correct and clarify.
I'll second.
Great.
Okay, taking the vote. Brown,
Yes.
Bradley,
Yes.
Shivers,
Yes.
Guzman, Mark,
yes,
Mercado,
Yes.
Munoz,
Yes.
O'Reilly, Poindexter, Robbie,
Yes.
Starr, and Krieger.
Yes.
8 yeses, so the motion carries.
We're going to do all of our votes right after lunch from now on. It moves pretty quickly. Well, that's fantastic. Thank you, Joel. I know I know Ken did a lot of work, and I really appreciate all of your work on this. And I think there's a whole world of lawyers for whom this can be very beneficial. So, and I look forward to our public comments to see what they spot that we haven't. So let me see what's next on our agenda here. So next, we're going to talk about the ABA 1.16 proposed revisions and whether something like that should be considered in California. And Deepika, are you going to be speaking about this now?
Sure, I'm happy to give a quick overview, and I'll start by saying we're at the very beginning of this process, so interested to hear what the rest of the group thinks about the amendments and incorporating them into California. But when the working group met to discuss, our discussion generally fell into 2 main buckets of issues and questions. I think one is, whether these amendments from the ABA's version of 1.16 really add any new duties, or whether this is really just at most a clarification of existing duties that were already implicit in the rules. And looking at the ABA's report and the resolution, it seems to acknowledge that the amendments are making explicit in the rules what was already really an implicit duty and an existing obligation that attorneys have to conduct, client due diligence. And I think that's especially true when you look at the amendments to subparagraph A, just really clarifying what that pre-existing duty was and making it explicit in the letter of the rule. So I think there's some understanding that these are not new obligations, just a clarification of existing ones. And I think there's a question about the utility of, making that explicit versus leaving it implicitly recognized by California's version of the rule. And I think that the second issue we spent some time discussing is, really the absence of more specific guidance here on the types of inquiries that lawyers need to be engaging in, if this is made explicit, how far lawyers need to push with their questions with clients, the impact, right, that kind of dynamic might have on the attorney-client relationship of trust. There doesn't seem to be much guidance out there yet beyond kind of just what's in the language of the rule and the amendments to the comments, which do have, factors to consider and a couple examples, but not much beyond that. So we discussed generally, if there were to be an amendment to California's rules, is there a way that it could be done to provide more helpful examples and more clarity about the scope of this obligation? Our working group meeting, I think, was back in December. So I'll ask, Brandon, Bill, I don't think we have Sarah yet. There's anything I left out of that summary.
Topeka, before we get too much further, could you just highlight the changes that we're going to be talking about, just so I'll have them in mind?
You're on mute,
Okay, you're
Deepika.
on mute.
How's that? Is that better? All right. I think we go to page 7 of the PDF that we can see. There's a helpful red line to show what the new obligations are. But it's generally in subparagraph A, just making explicit that lawyers have this now explicit duty, previously implicit duty, to inquire into and assess the facts and circumstances of a representation, determine if they can, accept or carry on with the representation. And then specifically talking about withdrawing from a representation if the client or potential client is trying to use the lawyer's services to commit or further crime or fraud. And then if you look at the amendments to the comments, if you scroll down, I think, to page 8, we'll see those in comments 1 and 2, which just provide more clarity, I think, on what these particular amendments are trying to achieve. It's a continuing obligation throughout the course of the representation, and some examples here of what you can see, the types of things that might trigger, a red flag and an obligation to start digging further. And comment 2 below that has a lot more kind of specific factors to consider when you're digging into this analysis of, the due diligence on a client. I think the report that accompanies the ABA's adoption of this talks about how the focus of these amendments was really on, potential money laundering, for example, but the end of the report also talks about how this type of amendment could push, potentially much further than that into other types of potential client wrongdoing. So kind of triggered by money laundering concerns, but certainly not limited to that.
So Topeka, I didn't have any memories of us going much beyond that. So to the extent we discussed fascinating and insightful things, it's been lost in my brain. But I thought we were starting to lean towards the conclusion that because this is already implicit in California's rules, and that this does raise new questions as to what is the nature and depth of the duty of inquiry, how disruptive and how expansive, and we don't have answers to those questions. We were reluctant to be too enthusiastic about making these sorts of changes in California. Maybe I could be just remembering my own thoughts. I'm not sure that was all of our thoughts, but
No, I
That's
think
also
you're
my
right.
recollection.
Yeah, that's, I recall the same, Brandon, and I think, yeah, we were inclined to leave our version as it is. I mean, it seems like the ABA's version creates more problems or issues than is necessary. And trying to find that line of how far you go in inquiring into the client's case or the facts and circumstances was certainly not clear. And so I recall that being a concern that we had when we were talking about that.
Was any consideration given in your working group sessions about a distinction or a differential in the duty between litigation matters and all other matters, where the lawyer has a duty of advocacy in one, while you cannot assert facts known to be false before court, you also have a duty, provided you don't know that it's false, to make sure the client's story is told in court. So that might be slightly different from a transactional matter where, if you look at, what is it, the ball hunt case and a few others going back in history, where in a transactional setting, if you know somebody is relying on representations put forth in a document you're preparing for your client, you may have some greater duty to verify those facts, etc. I just wondered if you considered that, or do you think it's important to consider that, or what?
I don't remember considering that at all. That sounds pretty interesting. I think I was so unpersuaded as to any benefits coming from this clarification of duties that I didn't break it down. If we were recommending moving forward, I think your approach, Joel, would be one worth exploring. I don't see the benefits here. I think it's a very strange. They really do seem to have focused in all of their sort of examples on money laundering, as if that's the only wrongdoing that exists. I just don't think it's a really comprehensive approach to anything. I mean, you could just have a rule about money laundering and that we're all supposed to pay attention to that. But again, I'm not sure it makes sense, depending on the nature of any particular representation, how many levels of questions we're supposed to ask. You know, if you represent a business and there's a slip and fall in front of it, do you have to figure out whether that business is a front for something nefarious? I don't really know. It strikes me as not within your job, but that's.
Can I ask, why is this on COPREC's agenda? Are we being asked to?
The ABA wants everybody to do it. Everybody, let's just, don't leave California as the only money laundering friendly spot, I guess. I don't know. They want every state to consider this change.
Do we have money laundering covered some other way?
I'd always thought the can't assist a client with a crime was good enough. And I'm not a police officer, so I'm not like investigating my clients. I don't know. I mean, I'm not willfully blind to wrongdoing either. I mean, I always thought the rules as a whole gave us a decent balance, but the ABA, and again, the ABA is not making a new rule. They're just saying the existing balance requires you to be vigilant about these things, I guess.
Has it been adopted in all the other states?
Great question. I have no information about that, but I'm pretty sure it's not all the other states. I think this is a pretty recent ask. Erica, do you know anything about that?
Well, there's several states that just adopt the ABA model rules. So when those rules change, the jurisdiction's rules change as well. But I'm not aware, but I have not researched as to whether any other state has affirmatively adopted this change. But I believe it was in, what was it, November or October? It's pretty recent. So
And what was the impetus? I mean, I remember, I believe, Erica, you had some insight as to where this came from. The ABA was trying to maybe get out in front of the another rulemaking or legislative body on the on what attorneys are supposed to do? I can't remember if that was it. I don't want to speculate.
Yeah, I don't believe it was get out in front of another body. I believe it was at the request of the Treasury and the U.S. Treasury and other
Okay.
organizations because of this concern is my understanding. I think that's what's stated in the materials as well.
Okay.
I think page 12 of this PDF talks about exactly what Erica said, just some of those concerns that were driving kind of the enthusiasm for this amendment in the ABA.
The impetus, there it is.
So, Topeka, I'm asking for your memory because mine is poor. Are we just asking the committee today for their impressions, or are we making our recommendation to the committee today? Because I know we were all not favorably inclined towards this change.
I believe my understanding is that, we're seeking a general discussion today, kind of against the backdrop of the working group's kind of inclination towards not adopting this type of amendment. And it's my understanding that, some kind of written response, like a memo kind of setting forth that we considered the amendments and our decision on that would need to go back to either Erica will correct me if I'm mistaken, the California Supreme Court or back to the ABA.
Yes, I believe it would be to the California Supreme Court. Chief Justice Barrera did forward this to the State Bar for consideration. The State Bar received it independently as well, but it was sent to the State Bar, and then based on COPRAC's role in considering amendments to the rules of professional conduct, it was provided to COPRAC for that consideration, and then go back. This is not, to my mind, something that would go to like the Board of Trustees or anything like that. There's no public comment process because it's just the decision to basically not move forward with the rule. But I do think it would benefit everyone to have some sort of analysis in that response, as opposed to go back to what Joel was saying earlier, and you, Brandon, as well, like just a no or yes answer that some of our opinions had from the past.
Yeah, my recollection was when we talked, we wanted to get some input from the group as a whole as to their thoughts in light of what we discussed in the working group. And then, like we said, then we would prepare a memo based on that discussion with our recommendations. So anyone?
Yeah, we're looking for thoughts, committee. Help us out here.
Well, the only utility to this that kind of pops into my mind is, it's good advice to make sure you don't get caught up in one of those things where, I want to hire you as a client to recover my $20 million lottery winnings, and put here's a cashier's check in your trust account. Then you get scammed by it and all that stuff. But I don't know that that's ought to be in the rules of professional conduct.
I mean, I agree. That's kind of what we were talking about, is that's implicit in, the rule. You don't, advise a client to break the law, or I forget, I'm being super general here, but that's what we figured. That's already implicit in that rule. And there's no need to add another rule that's, basically duplicative of what the rules already state.
Well, I agree with the working group. I mean, there are a lot of ambiguities in this. There's at least 3 or 4 that you can see right off the top that you can drive a truck through. But I don't see the need for it in the first place.
Yeah.
Besides the rules that are already there, I wonder what the motivation was to put this together in this way.
Yeah, it looked like somebody took a hard focus on a narrow issue and then found a place to try and stick it. And maybe it's an issue worthy of a hard look, but where they've stuck it, I don't think is correct.
I mean, yeah. What is the thing? Is it, if it's money laundering, why not have a rule about that? Right.
Yeah.
I mean, it almost seems like, and we may have talked about this in the working group, but now that I'm thinking about it, is this amendment to 1.16 maybe ought to be in a note to the rule that says you can't counsel your client to engage in unlawful conduct. You know, have an example such as money laundering, and there's, you know, and maybe in that note we have a statement or something to that effect would say, you know, there's a duty to investigate if you suspect your client's trying to get you to launder money for him or her or it. That's kind of what we may have talked about. We may not have. I just thought of it. It sounded familiar, but
it's kind of a grab bag because there's also
Yeah.
like a lawyer wellness component, you know.
right.
There's a money laundering aspect. There are other things, as Brandon said, I don't have the ability to assess when I first get a call whether the representation will implicate a violation of the rules.
Right.
It might.
I agree.
So maybe the next thing we do as a working group is outline or prepare our short statement of reasoning as to why we don't think this is a great idea and bring that back to the committee for discussion and input. Does that sound reasonable to everyone?
Yep.
Great.
Yes.
And I can assist the working group. There are many instances in the Rules Revision Commission and otherwise where, you know, they've taken up consideration of whether or not something should be adopted or not. And so we could certainly provide that as kind of a template if you want something to structure your analysis around.
That would be great.
Great. Great. Okay, wonderful. So let me see what's next here. All right, Erica, do you want to talk about the request? And we heard in the public comments today about the lawyer assistance with access to reproductive health request we're dealing with?
Sure. So I can kind of kick us off. So this goes back, trying to think of when we started on 8.3 last year, about a year ago, I'd say, is kind of when this really initially started. So as part of the requests surrounding 8.3 that ultimately led to Rule 8.3 paragraph C, which provides an exception to the duty to report misconduct where it would be a criminal act in another state, but not in California. Associated with that came a request to draft an opinion on this topic of whether or not it is, if a California lawyer can assist an individual residing out of state with obtaining abortion related access or services within California. So as you'll see, this was prepared by staff in our office. And as you'll see in the footnote, the first footnote, there were 6 hypotheticals that were provided in the request for the opinion that have been consolidated into, I'd say it's 3 hypos essentially. And so, you know, there's several authorities that are pointed out in this opinion. I think what is most important for the committee to focus on is Rule 1.2.1 in its consideration. As you'll see, 60680, I'm sorry, 606.8a, excuse me, talks about the duties to support the laws of the United States and of this state. And so arguably, you know, this type of conduct would be permissible under that statute. What is interesting is that 1.2.1 does not have that qualifier. It just says the any law, and is not clear that it's just California law. And then if you attempt to use 8.5, the choice of law rule to address this, it doesn't really help in this circumstance because well, at least that's my brief analysis, because the conduct would occur in a state where the rule would be violated to some extent. So I think that's worth considering. And I think kind of just big picture is to consider the direction based on the existing authorities the committee thinks this opinion would lead toward. And then based on that, if you want to move forward with more work on this topic to kind of flesh out something that could be in an opinion, whether the committee wants to move forward with other possible changes, such as a consideration of a rule amendment, or if it's not something that COPRAC wants to weigh in on.
So this would require, beyond RPC modifications, BMP code changes. If COPRAC were interested in recommending a result wherein a California attorney would not be disciplined for providing such assistance.
Correct. So it's kind of an interesting issue. So as was pointed out in the public comment this morning, there's based on Prop 1, there's a California constitutional right to have an abortion in California, essentially. And that's, I believe it's Article 1, Section 1 of the Constitution. So that exists. And then, on the flip side of that, there are some states where it is criminal conduct to assist somebody in seeking abortion-related services, including leaving the state to do so. In some states, it's criminal conduct. In some states, it's civil conduct. I think that is certainly an area that if the committee wants to move forward for a working group or staff to explore in more detail about what is the existing law. If it's criminal conduct, it gets a little bit more complicated on the state bar side because the state bar by statute does reciprocal discipline for attorneys that are convicted of a crime in another state. That is not the case if it would not be a crime in California, but that's an affirmative defense in a disciplinary process. So that would still lead to, the consequence of one having to defend yourself, and then unless the matter is sealed, it would be something that's public on, a person's My State Bar profile that consumers sometimes access when they're looking into hiring an attorney. So that's another consideration that would require a statutory change, which is, outside of the ability of this committee, although it's certainly something that the committee could, recommend to the board and then move forward. But I think the big thing is really consideration of 1.2.1. So there's kind of three buckets. It's one, does COPRAC want to do anything here? And then two, does COPRAC want to clarify in some way, be it an ethics opinion or in the rule, if the committee doesn't feel they can do so in an ethics opinion based on existing law, that this is something that is not going to lead to discipline. And then the other issue is just if you do commit a crime related to this in another state, if this committee wants to weigh in on whether or not an individual should be required to raise an affirmative defense if OCTC were to move forward with prosecution. A lot to unpack.
Has COPRAC ever done a opinion along the lines of, I know the rules technically say X, but we don't think you should prosecute X in certain circumstances? Have we ever done anything like that?
I don't believe so. I think the closest that the committee's ever gotten to this space is the marijuana opinion, and that one dealt with supremacy clause issues. So it's just a different can of worms than this, where it's state-based disputes as opposed to federal versus state.
But our note in 8.3 kind of came pretty close to that.
Yes. So 8.3 does this essentially by saying you don't have to report another attorney who engages in criminal acts for any issue where it's not a criminal act in California. Obviously, that was developed based in part on this organization giving public comment recommending that exemption, but that's just the duty to report. That doesn't actually govern the attorney who engages in the conduct.
Just generally, I was trying to think of another circumstance, and I couldn't think of one where conduct that was criminalized in a different state is protected by the California Constitution.
That's a good question.
Well, I got another question while we're pondering that one, and that is, this may be a stupid question, but I'm okay with that. I'm looking at this, and the footnote with the hypotheticals, we're talking about California lawyers and people in Texas, and maybe they're telling somebody to go to Tennessee to get health care treatment in this situation, et cetera. So, are we somehow getting into the area where we're mandated not to go, which is an unauthorized practice of law with this?
So I think maybe, but I think there is a hypothetical that can exist without that. So you're licensed, in California and in another state, and that other state has made seeking abortion-related care illegal. There are several companies that, when Dobbs, the case came out addressing this, said, we will assist you, employee, to leave the state where abortion is illegal and seek an abortion in another state. So in that situation, that's essentially what's in capacity 1, hypo 1. You're advising an organization on how to navigate this on behalf of their employees. Capacity 1, hypo 2 is advising an individual, advising on healthcare benefits in kind of the same space. And then capacity 2 is advising an individual, in a individual attorney-client relationship as opposed to organization as client. Does that answer your question, Joel? I think we're dealing with an attorney who's licensed in multiple jurisdictions, including California. Otherwise, yes, I do think if you had a hypo where they're in Texas or in any other state and not licensed there, I think we're going to avoid that based on the UPL restriction.
I was not looking for a particular answer or even an answer. It just was a curiosity. It just seems to somehow be involved with that. And then I'm tempted to say it, Jeff, maybe we should ask Tommy Tuberville about how the military does it, providing benefits for people. But that's a facetious question, obviously.
Sarah, you have your hand raised.
It's a good issue to spot. I guess we could easily find ourselves in that area without thinking about it. Not a dumb question.
Yeah, it just seems like from my review of the outline that, it doesn't seem like something we can necessarily comprehensively address through an ethics opinion or even through a recommended amendment to the rule, given that we'd also potentially need to amend this State Bar Act. But my question is, this is similar to what the question Brandon raised, I guess, but could we also recommend with the Office of Chief Trial Counsel adopt a policy that it just wouldn't discipline attorneys? That could be adopted in connection with the, either an ethics opinion or a rule amendment.
So I have no ability to speak on behalf of OCTC, but what I would say is I think it presents an interesting conflict for perhaps that office where COPRAC and the state bar is aware of a rule arguably that would prevent this type of activity and statutes that prevent this type of activity, and in California, and asking OCTC to have a do not prosecute type arrangement that would basically indicate that they are not moving forward with the prosecuting somebody based on applicable law. I don't know that if they would or would not be comfortable doing something like that.
Yeah.
My first, I guess where I'm coming out is, I think the ideal method to address these concerns is probably through the legislature. And we are in a state where the legislature seems really receptive. I mean, they are assertive on this issue vis-a-vis other states. And it seems as if they just haven't really noticed this particular gap in the attorney conduct discipline area. So it seems that we are not necessarily the vehicle to fix this. If the legislature was unwilling to fix it, maybe we recommend no prosecutions would be more vital. But it seems like the best thing to do is to fix it so that there can be no prosecutions, and because we don't know if the OCTC would listen to our letter anyway.
But just as a thought exercise, we could say, for example, in an opinion, that because the California Constitution protects this conduct, this behavior, wherever it occurred, for a California licensee would not violate California's rules.
Right. It's the reciprocal discipline thing that is challenging, right?
Yes, but I think you may need some clarity under you'd have to engage in that analysis, Dan, under 1.2.1 and 8.5. Because if you're in any state that makes it illegal, if you're in a state where you cannot.
To me, the analysis would be, sorry, I interrupted, but the analysis would be just very quickly, the California Constitution preempts the rules of professional responsibility, professional conduct. So.
Does the California Constitution empower a California resident to engage in out-of-state protected conduct or something like that? I mean,
that's not the question. The question is whether we are going to do some kind of a disciplinary procedure here that would violate the California Constitution.
Right. Yeah. So it takes it entirely out of the rules, right? Or the preemption.
Would
I still think the jurisdiction matters.
Come up with a very short opinion or statement that that's the fact, and that's our opinion, and there should be no discipline for doing it because of constitutional provision says it can't be punished for aiding and assisting and abetting and all that.
Would the California constitutional provision apply to an attorney licensed in multiple jurisdictions who assists in the conduct in another jurisdiction?
That to me, that takes us sort of in a circle, because we're not really in the business of interpreting California Constitution, right?
Right.
We have judges to do that, et cetera, and other legislators, et cetera. Yeah. But it isn't completely without it's not completely outside of our purview, because despite the individual 6 different scenarios, the question is, would a California licensee be disciplined for this? Should they be?
Then what's the this? What's the exact this?
The conduct that's illegal elsewhere, but that is protected by the California Constitution.
Okay, so, and that would be, like, I guess in this hypothetical, if I advise somebody in Texas how to come to California to get reproductive health care that's prohibited in Texas, and somehow I'm convicted or accused or whatever of violate that law, have I then also violated some oath I've taken as a California attorney?
Yeah, and to me, the oath includes, as our public's comment this morning pointed out, not to violate the California Constitution. So what are we talking about here?
I do think, I'll just flag that I think I'm looking at, it's section 1.1. I think I said section 1 earlier, so apologies. The state shall not deny or interfere with an individual's reproductive freedom is the clause. And I wonder if assistance fits in the interfere. It's preventative versus proactive, to me, is kind of the distinction that I wonder if it would require a COPRAC to make a legal determination on, to your point, Dan, about a judge needs to weigh in on this.
Yeah, I don't think we can do that.
So, I mean, 8.5. I mean, yeah, I'm just trying to figure out how many rules would need to be tweaked and which of those rules we have any voice in, you know. But again, to my other sort of practical consideration, you know, I'm not of the impression that that we're dealing with a legislature that's unwilling to fix this problem or this dilemma or, you know, contradiction in the law. What role, if any, does COPRAC have in bringing things to the attention of the legislature? I mean, does the state bar have a separate legislative liaison committee, or is this something where we could have a role in bringing the legislature's attention to this issue or something?
Yes, the state bar does have that. Typically the state bar, I mean, this does affect licensees. And so the question would be if this is something that the legislature, so how this works is the legislative team at the state bar presents priorities to the Board of Trustees as legislative priorities, things that they want to either pursue or take an opinion on at the legislative level. And then the board determines whether or not to take a position on a particular issue at that level.
Yeah, I recall on several occasions over the years with the mandatory fee arbitration committee, there were, I think, 2 or 3 times where we suggested legislation, and then there's a process that goes forward with the state bar and the trustees and all that. And then the question is, can we, should we, will we suggest some legislation and put it into the hopper for that process?
The marijuana opinions, I mean, did say that in some way. They did say that we're not going to enforce federal law over California law in some circumstances, or we wouldn't think that that would be a violation, even though federal law, it's criminal still.
But what if we decided we wanted to do this? What would we say? What would be the suggested legislation? I mean, I feel like if we just drop this, there's going to be a whole group of people who are going to be quite disappointed with our lack of action, and that disappointment might be valid. So if there's something that we can do and craft it, should we think about trying to do that and then see what we craft and then decide if we push it on for a recommendation for legislation or not?
I mean, the referral, the sort of thing that we're talking about might be something like Brandon described, which is we just point out to somebody, whoever that may be, that there's an application of current statute and the rules of professional conduct that may be unconstitutional. So take a look.
Yeah, should we maybe get some volunteers for a working group to come up with some of the options we've discussed and not draft, but just outline like what they might look like, where we would go with them. You know, what would it look like to say we recommend no prosecutions? What would it look like to say we are making a suggestion to the legislature to look at this statute and its apparent conflict with the Constitution on these issues? You know, And then we can bring it to the next meeting and talk it through. Just trying to figure out a workable path forward. This is interesting because there's like two kinds of silence the committee has. There's like the post-lunch silence, and this is like the legit, we're all deep in thought on this really complex issue. But who's excited to volunteer for a little working group?
I'll volunteer.
Fantastic.
Yeah, I'll volunteer.
Okay. Do you think we need more than 2 people, or is that enough just to, because we're really talking about some high level outlining?
Brandon, are you staying on? This was originally a working group of 1.
Yeah, it was a working group of me not making up my mind about what to do with a. Yeah, I'll stay on. I'll be happy. So there'll be 3 of us.
And do we have a next meeting, or is it just a symposium?
It's just a symposium, and then our next meeting's like in May. Is that
Right?
Yeah. So okay, good. So because I don't have a whole lot of time in March to work on this, so this will give us a little bit of time to work on it.
And so anyone who gets a jolt of inspiration, reach out to one of the 3 of us or all of us and just tell us what you're thinking so we can think about it too.
Is there any other state that has dealt with this? I'm just always wondering.
Yeah, it seems like something New York should be dealing with, right? I would think. I don't know the answer to that. How do we find that out?
Question.
You can ask I can put an email in April to see what if anybody knows of. Ask the listserv. It's
Yeah,
the quickest way.
That's a good idea. That's a good idea.
All right.
Okay, I'll do that.
I
Fantastic.
think there's some people in the western half of Oregon who thought about this.
I bet you're right.
They may not have a constitutional provision that's similar, but
Yeah.
Or also, wait, what state did Washington told Idaho, don't try and
Yeah.
prosecute people who come to Washington for reproductive health care.
Right.
They've done something.
And I want to say Illinois too, but maybe I'm remembering that wrong. Maybe I'm thinking of the migrants. All kinds of interstate,
Yes.
intrastate issues.
Okay. Well, I think this is a confounding situation. This will be interesting to see if we can come up with a path that we all think is useful. Erica, am I missing anything? Is that sort of the end of the agenda for the day?
That is the end of the substantive agenda. I have a few reminders for everyone, but otherwise
Okay.
I believe that's everything. Although last meeting I said it was everything and I omitted 1.16. So if anyone has anything else they're prepared on, please let me know. Okay. So just wanted to make you aware. So the State Bar is in the middle of seeking volunteers who want to be appointed to various committees, including COPRAC. That application period ends on April 15th. So if you have, if you know of a colleague or anyone else who is interested in joining COPRAC, I would certainly invite you to invite them to apply. The application is available on the State Bar's website, and we have 3 vacancies on COPRAC coming up for next year. So there's that. And then as we just mentioned already, but just a quick reminder. So the next meeting of COPRAC, substantive meeting in this format is not until May 10th. And that is an optional in-person meeting at the Los Angeles office. So you should have received from Angela a reminder to, make travel arrangements now, or, if you want to do so later, that's fine as well. And then the next event where everyone will be in attendance will be at the symposium on April 19th, if you're able to attend. I think that's it.
Great. Well, thank you all for a very thoughtful day of work. I hope you each have a great weekend. Thanks a lot.
Thanks, Brandon.
Bye, everybody.
Thank you.
Thank you.